Hello, everyone. I'm pleased to welcome you to today's panel discussion on the Federal Trade Commission's new rule regarding non-compete agreements. My name is Eric Eisenman, and I will be your moderator today. I'm a partner here in Husch Blackwell's Milwaukee office and also serve as the chair of our firm's National Labor and Employment Practice Group. We have an excellent group of presenters for you today. We're going to provide some valuable insight about the proposed rule and the advice that we're providing to our clients. Before we begin, I'm going to cover just a few housekeeping items. At the bottom of your audience console, there are a couple application items or application icons that you can use during the program today. I'll also note that you can toggle the size of the screens in your console right now to make the speaker screen bigger or smaller, or the slide screen bigger or smaller. Let's keep that speaker screen not so big that we are seeing us in full HD. If you have questions during the webcast, you can submit those during the question box. We're going to try to answer as many questions as we can, but if we do run out of time, we will follow up and provide information about those questions after the webinar is completed. We've built in some time at the end of our presentation to hit some questions that we received ahead of time. So our hope is we're going to be able to get to most of those through the presentation today. A PDF of the slide deck that you're going to see is going to be available in the program materials folder in your console. And this program has been approved for legal education and HR hours. For live attendees, you can report those hours by clicking on the CEU icon at the bottom of your screen. And a certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast that you can watch and share with others in your organization. Towards the end of our presentation, we're going to ask that you complete a short survey. We use the feedback that you provide us to help make sure that our future programs are applicable to your needs. That's all for housekeeping items. Let's get started with the program. On January 5th, 2023, the Federal Trade Commission announced a proposed rule that, if enacted, would amount to a near total nationwide ban on the use of non-compete agreements. As I've mentioned, we've gathered an esteemed panel of Husch Blackwell attorneys to answer your most pressing questions about this proposed rule. Joining me today are Wendy Ahrens, Scott LeBlanc, Chris Otley, and Michael Schreier. Wendy is a partner in our Madison office, and she leads our firm's antitrust and competition practice. Our antitrust and labor and employment teams frequently work together, and this is a particular topic that is a great example of how it can be valuable to have advisors with expertise in both of those areas. Scott LeBlanc is a partner in our Milwaukee office, and he has been leading the charge in our firm regarding the analysis and assessment of this proposed rule. A substantial part of his practice involves helping clients draft and enforce the kind of restrictive covenant agreements that could be impacted by the rule. Chris Otley is a partner in our Denver office, where he practices in all areas of employment law, but he is also my go-to resource when clients find themselves in litigation regarding non-competes, non-solicitation agreements, and trade secret disputes. And last but not least, Michael Schreier is a partner in our Washington, D.C. office. Michael brings a unique perspective to this discussion, given his deep experience in both the labor and employment and government contracting spaces. His insight into the federal rulemaking and enforcement process has been invaluable to our team as we've analyzed this FTC proposed rule. That's it for introductions. I'm now going to turn it over to Chris to set the table for us with some background about the current non-compete landscape across the country.
Thank you, Eric. Much appreciated. I didn't realize I was your go-to resource. So as Eric mentions, I do devote a significant amount of my practice, particularly on the litigation side, to the issue of restrictive covenants. We thought it might be good for us to make sure we're all on the same page before we go into the meat of what the FTC's proposed rule is. If there's one kind of piece of advice I give to all clients about restrictive covenants, is that there is a gross misunderstanding of what restrictive covenants are and when they're enforceable and when they are not. So we thought we'd try to level set right here from the beginning. What we're talking about when we're discussing restrictive covenants is really three types of restrictive covenants. There are non-competition covenants. That's the subject of the FTC rule. There's non-solicitation covenants, and that relates to employees and customers. That's touched upon in the rule, but it's not the focus of this proposed rule. And then there's your standard confidentiality agreements, which are relatively unaffected by this. So restrictive covenants, generally speaking, are going to be entered into with employees, but sometimes they can also be entered into with in partnership agreements and membership interest agreements, LLCs, and the like. They typically will have some component that says that an employee, both during their employment and most importantly post-employment, they will have restrictions on their ability to either compete or solicit or share any confidential information that they gained while employed. And these restrictive covenants are, generally speaking, going to be governed by principles that require a balancing of the interests. And the balance of the interests is going to be between the employer's rights, the employee's rights, and the public interest. It's not exaggeration to say we have about 150 years of case law with respect to when are restrictive covenants enforceable and when they are not. Generally speaking, there has been a movement afoot in the United States in the last 10, 15 years to make restrictive covenants less enforceable. Generally speaking, it's going to be the state law that governs this. We're going to go into this a little bit more later on, but the FTC has almost no history whatsoever in attempting to restrict attempting to govern restrictive covenants. This is a state law issue. Some states have very specific laws that are mandated by the legislature. Some states have relied simply upon the court system and common law. And what they're usually doing is they're trying to enforce, trying to find basically on a sliding scale, trying to find ways that a restrictive covenant is not going to be so overbearing upon the employee that it actually limits competition. There's a general belief that if an employee has a skill set that they've learned because they've gone to medical school or business school or whatever, they should be able to apply that beyond a particular competitor. Balanced against that interest is that employers also want to make sure that their employees have access to all of their confidential information and trade secrets, are able to take that information and immediately start working for another company. And so you're going to hear a lot about during today the importance of trade secret protection and the importance of allowing employees free mobility to perform their services where they want. The three kind of cardinal principles that all the courts will look at under common law rules is going to be reasonableness with respect to scope, geography, duration. By scope, I mean just what is considered to be a competitive activity. Obviously, someone can't sign an agreement that says if they work for the Yellow Pages company, they then can't go ahead and take a position at Google. That would be beyond a reasonable scope. Geography relates to, it's not infrequent for us to see restrictive covenants that say that an individual will choose not to compete or solicit customers within a particular geography. Maybe it's tied to a particular business or where the individual had job responsibilities. So if it's a salesperson, it might be their own territory. If it's a medical practice, it might be within 50 miles of where the particular hospital is, where that individual works. It just needs to be reasonable. It can't be usually worldwide unless the business truly is a worldwide business. And then finally, duration. And duration really goes along that sliding scale that I mentioned before. Infinite duration restrictive covenants are almost never going to be enforceable. The much more common versions that we see with respect to executives and high-level individuals of an organization are either going to be 1 year, 18 months, 2 years. The lower level down the individual goes within the chain of authority of the company, the less duration will be considered to be enforceable. So that's the background rules against which each of the states have identified how they're going to enforce or not enforce these rules. It is not uncommon for me to hear employees say that restrictive covenants are never enforceable. And even in states like California, Oklahoma, and North Dakota, that's not quite true. Those states do have almost near complete prohibitions on non-compete agreements, but they still allow for some sort of restrictive covenant that limits the sale owners who have just sold their interest in a business. And in fact, the FTC rule specifically addresses this and actually makes that rule slightly more restrictive than even those three states. Kind of in between California, Oklahoma, and North Dakota, and the states that still apply all those common law rules that I just went through, that's been a big movement afoot in the last 10, 15 years, primarily states that are in the West, but not exclusively. States like Illinois, Washington, Nevada, Colorado, District of Columbia, several other states have started to put in even more restrictions than just those common law rules. Those restrictions are going to be based upon, for example, not exclusively across all those states, but some of those states, for example, will limit restrictive covenants related to non-competes only for highly compensated executives. And so that would include places like Illinois and Colorado. It might be limited by occupations. Healthcare pops up an awful lot in this space. It might have a notice requirements, and it might also have some duration requirements. And then there's kind of the rest of the country that still works under the same rules that have developed in our common law rules. That's primarily in the South and the Midwest. Again, not exclusively. Obviously, Oklahoma and North Dakota fall right squarely within the Midwest. But those states, generally speaking, will apply the exact same principles that we've had before. So based upon that level setting, I will first say that there is a treatise out there that identifies the 50 states and covenants not to compete in those 50 states, or all restrictive covenants in those 50 states, and it runs to about 2,400 pages long. So I did a gross disservice to you if I made you think you understand what restrictive covenant law is right now. With that, I'll hand it over to some people who are more interested in talking about this. Thanks, Wendy.
Thanks, Chris. Well, as an antitrust attorney who has been practicing for close to 20 years, I've seen a marked increase in the last few years with respect to state or federal antitrust enforcers who have raised issues or questions either with respect to non-solicitation agreements or non-competes. While historically Chris is right, the FTC has not regulated non-compete agreements between employers and employees, their interest in this issue has been growing over the past few years. So it's no surprise that the FTC rule was issued when it was. It's really the culmination of a persistent drumbeat by the Biden administration and others at the federal level, including Congress, to use antitrust law to address labor market issues that are perceived to negatively affect worker mobility and wages, among other things. The basis for the rule is Section 5 of the FTC Act, which is, as you might imagine, provides the FTC with authority to enforce it and broadly prohibits unfair methods of competition, among other conduct. And it's really the unfair methods of competition prong of the FTC Act that's at issue here. This drumbeat to regulate non-competes at the federal level has, as I've mentioned, been building for a while. It started in earnest in July 2021, when President Biden issued an executive order titled Promoting Competition in the American Economy. It was a very broad executive order and requested a number of federal agencies to take action to address issues affecting competition in some manner. So it really wasn't a surprise to see that the executive order directed the FTC to exercise its statutory authority to curtail the use of non-compete clauses and what the FTC deems as the unfair use of non-compete clauses or other agreements that may unfairly limit worker mobility. Well, the drumbeat got a bit louder this past fall when the Federal Trade Commission released a new policy statement regarding the scope of what constitutes an unfair method of competition under Section 5. This policy statement, however, didn't directly address non-competes, but it adopted a very expansive view of the FTC's authority and set forth a more lenient and more vague statement, a standard for the FTC to challenge certain conduct as illegal. So it certainly indicated in the fall of 2022 that the FTC was laying the groundwork for something big to come, including this potential new rule. And thus, the agency finally followed through on the president's July 2021 order this past January with the release of the proposed rule. And FTC Chair Lina Khan provided the FTC's rationale for the new rule, which is that non-compete clauses, in the FTC's opinion, block workers from freely switching jobs, depriving them of higher wages and better working conditions. And then they're also deprived businesses who need a talent pool that they can build and expand. And it may also curtail innovation and sort of starting new businesses. The FTC's estimate is that the proposed rule would increase workers' earnings by between $250 and $296 billion per year. As part of the FTC's rollout of this new rule, the day before its announcement of the rule, it issued a statement and consent orders regarding 3 enforcement actions against companies that the FTC believed were violating Section 5 of the FTC Act through their use of what they deem as unfair non-competes. And the FTC stated that, the companies illegally imposed these non-compete restrictions on workers who were in lower wage positions, including security guards, those who worked in manufacturing for glass companies, and also some engineers, and that it prohibited these workers from seeking or accepting work from another employer operating a competing business after they left the company. So in each case, in each of these enforcement actions, the FTC ordered the company to cease enforcing, threatening to enforce, or imposing a non-compete on the affected workers. And the companies were also required to notify all affected employees that they're no longer bound by the non-compete agreements. And this was really a preview by the FTC, right, of the rule that was rolled out the next day. Notably, one FTC commissioner dissented to these enforcement actions, contending that the investigation was very brief. These companies wanted to settle, and they had every reason to want to settle and not to fight the allegations. So the investigation really wasn't all that comprehensive, as evidenced by a very brief complaint, 3 pages, against the companies. Furthermore, Commissioner Wilson said, she did not see any evidence of anti-competitive effects flowing from the use of the non-competes. And then more significantly, the complaints contain no allegations regarding their unreasonableness, the non-competes unreasonableness in terms of length, geographic scope, or subject matter, which is certainly a departure from judicial precedent over the years with respect to how non-competes are analyzed under antitrust law. So this flexing of the FTC's muscle in terms of its enforcement authority, again, was really designed to preview the potential consequences for companies who do not adhere to the new rule. That said, there are significant questions, which we'll discuss in a bit, as to the FTC's authority to promulgate and enforce a nationwide ban on non-competes. But before we get into that, I will turn it over to Scott to provide a summary of the proposed rule and some insights into it.
Great. Thanks, Wendy. So this is the meat of the sandwich. We've been sort of teasing this rule, and I'm sure a number of you have read up a little bit about it. The rule itself is sort of unusually short as far as government regulations go, but of course they couldn't help themselves, and they did provide a 216-page document sort of with the ins and outs and the explanations for why they were putting forward this rule. So I'm going to try and summarize it in just a few minutes now and sort of set the table for some of the questions that we have teed up later in the discussion. So starting with the rule, as Eric mentioned sort of at the top, this is a blanket rule that says that businesses in the United States, with very few limited exceptions, they cannot enter into or attempt to enter into a non-compete. So this would cover attempts to the extent that an employer wanted to give their employees a non-compete. The employee says, I thought the FTC said that this wasn't something that you guys could be doing anymore. You can't just pull it back and say, just kidding. That would be a violation of the rule as it's currently proposed. The second thing is that businesses cannot maintain a non-compete, and this covers the currently existing non-competes. So certainly enter into would be future non-competes. Maintaining a non-compete is the piece of it that applies to pre-existing agreements. And then finally, the last piece of it is to represent to a worker that he or she is subject to a non-compete. So this would cover statements by company personnel, supervisors, so on and so forth, that would make an employee think that they might be subject to a non-compete when in fact they are not. All of those would be violations of the proposed FTC rule as it currently stands. Now, what is a non-compete? Chris mentioned, talked a little bit about this. The FTC has gone forward and defined non-compete as any contractual term that after the conclusion of a worker's employment prevents a worker from either seeking or accepting employment with another person or entity or from operating a business. Now, the FTC realized that when they're talking about non-competes here, it goes beyond something that simply says non-compete in an agreement, or might use the word compete, or might use the specific language here, seeking or accepting employment with a competitor. There are certain kinds of restrictions that really have the effect of a non-compete, even though they might not use those magic words. And so what the FTC rule does is it also comes up with this concept of what they call de facto non-competes. And de facto non-competes are also prohibited under the rule. And when we're talking about a de facto non-compete, it's any contract clause that, whether or not it uses the word non-compete, or it says that you can't go ahead and work for a competitor, the effect of that clause is essentially the same as if you were subject to a non-compete. And so some of the examples that the FTC uses in their rule are overly broad non-disclosure agreements. This would be, for example, a clause that says you can't use any information about our industry for 2 years following your employment with us. That would essentially preclude someone from being employed by a competitor. That would be an overly broad non-disclosure agreement. The FTC rule doesn't specifically mention non-solicitation agreements, but certainly I think non-solicitation agreements are contemplated as being potentially de facto non-competes under the rule. So if you can think, for example, if there are two companies within an industry and they all service the same customer base, a customer non-solicit that says that you cannot be involved in the solicitation of any of our customers, that may in certain industries act as an effective non-compete. So an overly broad non-solicitation agreement in that context could certainly qualify as a de facto non-compete. And then finally, the last piece that they add in here are agreements that require workers to repay training costs that are not reasonably related to actual costs. So the specific kind of agreement that they're talking about here would be to say, if you leave us our employment within the first year, you're required to pay back half of your first year's salary. The FTC has recognized that those types of agreements, when they're not reasonably related to actual costs that you can justify, those can qualify as de facto non-competes as well. A couple other pieces of clarification, and again, we'll get into some of the details on this when we get into the questions, but the rule does apply to all workers, not just employees. So independent contractors, consultants, interns, whether the interns are paid or unpaid, and volunteers are all covered under the scope of the rule. Unlike what Chris had mentioned has sort of been the trend at a state law level, the FTC makes no distinction, at least in the proposed rule, between high-wage workers and low-wage workers. The FTC, in their commentary to the rule, recognizes that the rationale for having a blanket non-compete ban is stronger when we're talking about low-wage workers, but they feel like it's important, even for high-wage workers, to take the stance that non-competes are within the scope and should be subject to this blanket ban. So at this point right now, we're talking about a rule that makes no distinction between senior executives and entry-level workers with respect to the scope of the non-compete. It does not, however, include franchisees in the context of a franchise or a franchisee relationship. So that's kind of a unique there, and it does go out of its way to specifically mention that those types of non-competes are not included within the scope of the rule. There is also one narrow exception that's spelled out in the rule for non-competes that are entered into in the sale of a business. But as someone who spends a lot of time working on these types of non-competes, the really interesting thing here is that the FTC has said that this exception applies only to the owner of a company who has more than a 25% ownership stake in the company. Most states will recognize that sale of business exception regardless of ownership stake, but that 25% threshold is something that is new and goes even further than what California law would currently prescribe with respect to the sale of business non-competes. So really something to keep an eye on, particularly for non-competes in that M&A space. And then finally, before I kick it to Michael to sort of calm us all down and walk us off a ledge maybe a little bit with respect to this rule. I wanted to just highlight that this rule, again, is not just forward-looking. The rule requires employees to take action to rescind their existing non-competes and to notify their employees that those non-competes are being rescinded. So you can't just do nothing and sit on your hands and hope that your employees won't find out about this rule. An employer that doesn't take the necessary steps to notify their employees would be in violation of the rule as it currently stands. And the rule does provide some model languages for that employee notice. But this is a proposed rule. This is not a final rule. And so a lot can happen between now and when and if that rule should go into effect. And Michael's going to talk to us a little bit about that.
Thanks. And thank you for the introduction there. Yes, I've been doing this sort of stuff for government contractors, challenging non-compete agreements and enforcing non-compete agreements, as well as for about 30 years, I've been challenging federal administrative agency action, both rulemaking and adjudications. So I get to talk about the fun thing here about, now what, now that the FTC has proposed the rule. And as indicated just a couple seconds ago, the proposed rule is what it is right now, and comments are currently due on the proposed rule on March 20th, 2023. Now, this is the way the federal government works under the Administrative Procedure Act. They propose a rule, and they give the public an opportunity to comment, and then the agency that issued the proposed rule is supposed to evaluate and weigh all the comments, and then come up with a final rule. So this situation is a little unique from my perspective, because the proposed rule, as just explained to you all, is very draconian. But tucked into the notice of proposed rulemaking, the FTC proposes about 4 or 5 different variations on alternative formulations of the rule, based on either a total ban on all non-competes or a rebuttable presumption that that particular non-competes are unenforceable. They toss that out as a possibility. They toss out another possibility saying that maybe only senior executives should be covered by this, not everybody, but where that line will be drawn, they're not sure. They also talk about maybe the ban should only cover those who are exempt under the Fair Labor Standards Act, non-exempt versus exempt employees. And then finally, they in the proposed rule, they talk about maybe there should be a dollar limit as to compensation earned, and only those above a certain threshold would be eligible to have non-compete agreements, and those below a certain threshold would be prohibited from having them. So what's interesting in the notice of proposed rulemaking, both the three-person majority from the FTC and the sole dissenter actively invited the public to submit comments, to advise the agency about how their proposed rule should ultimately look. So the bottom line here is, the current rule looks very draconian. My guess, this is only my personal opinion, it was probably designed and written this way for shock value to elicit lots of comments. So if you have the wherewithal and desire, then I would certainly suggest that you may want to provide comments, because the FTC has never done this before, as you heard the other speakers say. The FTC has no background on this. So this is the public's chance to educate the FTC about how the real world works and how non-competes really work in various different industries. Whether it should be carve-outs for certain industries, should be for public sector, private sector, nonprofits, et cetera, et cetera. There may be ways to propose things to the FTC. So the important thing here is that the FTC is required by law to review all comments submitted before publishing a final rule. And only the final rule becomes effective, not this proposed rule that we're seeing here, only the final rule. And so the reality is that the only chance for the public to weigh in on a final rule may be right now through filing a series of comments. because afterwards it becomes a final rule, and then we're off to the races, which I'll get to in a couple seconds. So how long is it going to take for the FTC to get from comments due on March 20th to a final rule? Your guess is as good as mine, but based on my experience with other agencies, we're probably talking at least a good 6 to 9 months, perhaps even longer, particularly since the FTC is not particularly known as a rulemaking agency. I don't know if they have the staff to handle the flood of comments that they're likely to receive, but by law, they have to look at all of them and consider all of them before formulating any final rule. So let's assume we're talking late 2023, maybe early 2024, before a final rule is published of some sort. And then in the notice of proposed rulemaking that we've been talking about today, they talk about how the effective date for any final rule will be 60 days after publication of the final rule. And by publication, we mean publication in the Federal Register. Now, what's interesting about that is that they talked about how this is a, quote, major rule, not a typical run-of-the-mill federal rule, but a major rule under the Congressional Review Act. So they have to put in more lead time to allow Congress to have the opportunity to give a thumbs up, thumbs down on the rule. So after the effective date, then there's a compliance date that's built into the proposed rule. And they're saying that the compliance date is supposed to begin 180 days after publication of the final rule. In other words, 6 months after the final rule is published. So let's assume the final rule is published late 2023 or early 2024. We're talking mid-24, late 24 before any compliance is supposed to begin under the rule. Now, having said all that, then we get to the part that excites me, court challenges to federal rules. We've already seen a number of rumblings among major trade organizations that they do intend to challenge this or are likely to challenge this. And any court challenges could very well take another 1 to 3 years, from the U.S. federal district courts all the way up perhaps to the Supreme Court. So it's going to take a while for this to roll through the courts, and most likely, no guarantee, but most likely any final rule would likely be stayed or made not in effect pending judicial review. So, best case scenario, we're talking a couple of years before any final rule becomes enforceable, assuming it survives court challenge. Worst case scenario, a final rule could issue by July 4th. Highly unlikely, but always possible. So, what's the other possibility here? Potential for congressional action or a change of administration. As I alluded to before, there's this statute called the Congressional Review Act. It's only been used, 1 or 2 times before, where Congress can negate federal rulemaking, and they've used it. They used it the last time in early 2017, and very likely to do so again here. I would think if there's a change in control of Congress. And so similarly, if there's a change of administration, because we've seen this time and time again, that an administration of one flavor issues a rule, and administration of the next flavor comes back and rescinds the rule. So this is very likely, something that could happen here too. But again, that's we're talking the earliest that could likely happen would be early 2025. So the bottom line in all this is that yes, there's a proposed rule today. Probably the best thing to do, to the extent anybody's concerned about this and has the time and the wherewithal to do it, I would propose to submit comments to the rule, so at least the FTC can hopefully get educated, and it'll also take more time for the FTC to review, and we'll see what time does. So with that, I will turn it back over to our fearless moderator.
Thank you, Michael. So we've got a lot of really excellent questions that have come in here. We will try to touch on some of those, but I'm going to actually stay with Michael here for the first one. And we've touched on it briefly, but the question is this rule going to apply to all sectors and replace all state laws? How broad is the application of the FTC's proposed rule?
Well, again, it's really going to depend on what the final rule looks like. If the final rule looks exactly like what the proposed rule looks like, which, again, you can't, this is my personal opinion. Don't say that Michael said so. but I don't think it's going to look the same way when a final rule comes out. There may be some restrictions, there may be some limits, but currently, in its current form, there are no limits. It just talks about, non-competes in general across all industries, state, federal, private, public, nonprofit. It'll all get wiped out based on this rule, based on federal preemption. But again, we don't know what the final rule is ultimately going to look like after they review all the comments.
And good segue maybe to Wendy. That there are some carve-outs when we think about what the FTC's authority is here. Is this rule going to apply to nonprofits, or are there other entities by virtue of the sort of the jurisdiction of the FTC, which we would say are probably outside the scope?
Yes, that's a great question, Eric. The short answer is that the new rule likely will not apply to entities that are 501c3 organizations. As with most things, the devil's in the details here. So the longer answer is that Section 5 of the FTC Act has previously been interpreted as exempting 501c3 organizations. It's also previously been interpreted to exempt other organizations and companies such as banks, federal credit unions, common carriers, and persons subject to the Packers and Stockyards Act. The FTC's proposed rule actually acknowledges the potential for 501c3 organizations to be exempt, stating that some entities, who would otherwise be considered employers, may not be subject to the rule to the extent they're exempted from coverage under the FTC Act. And it goes on to say that these entities include an entity that is not organized to carry on business for its own profit or for that of its members. And so that limitation tracks the language of Section 5 of the FTC Act. I would just qualify that by saying every nonprofit organization, including healthcare nonprofits, are organized differently and may have different operations or arms of operations, including an unrelated business that, from the FTC's perspective, could call into question the organization's exempt status under the rule. So, we encourage you to consult with a tax professional if you have questions about your organization's exempt status. And of course, our tax specialists here at the firm stand ready to assist.
Great. Thank you. Something else that I thought I saw pop up in the comments and is worth expanding on a little bit is a topic that you touched on, Scott, about, how this rule might apply, if any, if at all, to non-competes that are sort of outside of the employment context. So equity grants, shareholder agreements, non-competes in the context of transactions. What's our take on that?
Yeah, I think for now, as the rule is proposed, that they apply to everything. So there's nothing in the rule that says this only applies to non-competes in an employment agreement. Very clearly, it talks about non-competes in the sale of a business, which typically are found in a purchase agreement. And I think that same rationale would apply with respect to non-competes in equity grants, bonus agreements, those kind of things. The way that the rule uses the term worker is very broad. So it applies to anyone who's providing services to an employer. Now, is a shareholder who is not otherwise an employee providing services to a shareholder, providing services to an employer? That's where I think maybe the scope of the rule might get a little fuzzy. And maybe we'll get some clarity on that in the final rule. But I think for now, outside of that specific narrow exception for an owner of more than 25% of a business in the context of a sale of a business, we have to assume that non-competes in any context, employment agreement, equity grant, bonus, otherwise, those are going to be covered under the rule. And in fact, the rule even talks about when we said it has to be a contractual term, was that too broad? The FTC says, well, some places might try to sneak a non-compete into their employee handbook and think that's going to fool employees. Do we need to make our language even broader to cover that? So I think it is very much their intent to cover non-competes under all of those circumstances.
So, a follow-up, a logical question might be, and I think we touched on it briefly, this concept of retroactivity, and I'll ask this to you, Chris. The broad question, and then there was actually a really useful specific question in the chat. Would the proposed ban be retroactive? Would it apply retroactively to these agreements? If so, the follow-up that I see in the chat, which I thought is good, what would happen with a payment that might have been made to the employee in exchange for signing that agreement, which is no longer enforceable, and what happens with the other terms of that agreement. Seems like a law school exam question, Chris.
And I loved law school, so that's perfect. So this is really the area where I don't think the FTC has put nearly enough thought into. Within the proposed rule, employers are supposed to rescind existing non-competition covenants or clauses. They're supposed to provide a written notice, and then they actually provide sample language in that written notice. And what the FTC says is the FTC's new rule does not affect any other terms of your employment contract. For more information, visit this link. The FTC doesn't get to tell the courts what to enforce and what not to enforce when it comes to employment contracts. The law of contract existed about a millennia before the FTC even came into existence. So it's really a far-reaching thing. So there's a general background. Again, I'm going to really do a disservice to the law, and all you contract nerds out there are going to laugh at how I'm going to describe this. But in general, employment contracts and all other contracts are usually considered to be integrated wholes. They're supposed to be the entire terms of the agreement. And if one provision of that agreement is held invalid because it's illegal or for whatever reason, courts will typically invalidate the entire agreement, particularly if it's an essential term. Now, a lot of agreements, as people are probably aware, have savings clauses, or they have provisions within the agreement that actually talk about how there's going to be severable terms. That's very common de facto language that we have in commercial contracts, employment contracts, et cetera. And so for the FTC to say, well, all of the terms of the agreement are going to remain in effect, that really is not giving any consideration to the millions of contracts that the FTC have told us have been entered into, and what are the basic terms of those agreements. So I don't think the FTC gets to assure itself so as much as it has. So here's the way I envision this. Let's say you have a standard executive employment contract, and then one of its provisions is a non-compete, as well as all the other provisions related to what do the executives get paid, what are their responsibilities, what happens if they leave for cause or not for cause. In that case, particularly if there's a severability clause, I can foresee that if this FTC rule goes into effect, that only one portion of that agreement is going to be excised out. And for those of you who are familiar with this area of the law, you've probably heard of blue penciling, which is that courts are empowered to excise an offending term but still try to meet the expectations of the parties with respect to the agreement. But what if, for example, the agreement was solely based upon a separation agreement with the executive, and the sole reason for entering into the agreement was the release of claims, as well as the the executive will not compete for the next year or whatever time frame it's in there? That might be too integral of a term or too essential of a term of the agreement, and it might invalidate that non-compete. And if that means the entire non-compete agreement is invalidated, what happens to the severance payments in that situation? Presumably that rescinds the entire agreement. And you can see this playing out both ways. You can see employers trying to say, well, I don't owe you the money anymore. Or you can see the employees saying, well, I'm no longer subject to other covenants that were contained within the agreement. This is a real big apple cart that's going to get overturned here if this rule goes into effect. And I just don't think that the FTC has really thought this issue through. If there's one area of rulemaking that I would weigh in on, I would first contact Michael. And secondly, I would talk about this, because this is a really big deal. And it's completely uncertain why the FTC thinks that it can tell state courts and federal courts how to interpret contracts.
Good segue. There are a number of comments in the chat here of individuals who are excited for the potential opportunity to say their piece to the FTC and tell big government exactly how far they're overreaching. So, Michael, how could an entity, a company, or a trade group, file one of these comments? And is there a risk associated with that? Does filing a comment like that or submitting a comment put a target on my back and make it more likely that I'm going to be the target of enforcement action?
Well, those are two very different questions. So let me address the first one first. And I'm going to geek out on federal administrative law here for a second, because this is what I like to geek out on. I'm not a contract guy. I'm a administrative law guy. So if you go to the Federal Register, and hopefully everybody has a pen and paper. If not, we can probably send the information later. If you go to the actual Federal Register where the FTC's rule was published, and that was at 88 Federal Register 3482, on January 19th of this year. On the very first page of the notice of proposed rulemaking, they provide all the information one needs about where and how to file comments. There is a special web page at www.regulations.gov that you go to there, and it's the central place for filing comments on all federal proposed regulations. You find the specific FTC regulation here, you click on the button, and you submit your comments. Or you can, if you're a dinosaur like me, you could also even file it using paper, and there's an address to provide as well. So that's how you do it. Do you need to be, a lawyer and a fancy big firm law firm to prepare and file comments? No. Sometimes it helps, sometimes it doesn't, but you don't need to be. And the FTC, like all federal agencies, is just looking for the public to weigh in. So the idea here is not just to say something, oh, we hate this stinks. Obviously everybody who's submitting a comment is probably going to be thinking that, except for certain select groups. So the idea is that if you're going to provide comments, you want to provide some good, either legal or practical or business reasons why they should change their proposed rule, or just throw the whole thing out. Now, to Eric's other comment, does this paint a target on your back? This is where you have to weigh a little bit about what you put into the comments, because you don't want to say, gee, I've been using non-competes for our fry cooks for the last 20 years. And we don't see any problem with having this apply to fry cooks who are making $15 an hour. That may put a target on your back down the road. But if you talk sort of in general terms,
by the way, those people are the reason why we have this rule. So let's just call it out right now.
Exactly.
Blame Jimmy John's.
So I'm just picking on that one industry just off the top of mind. But so you got to be a little bit careful about what you put in the comments. But look, as long as you talk generalized, industry specific or even company specific, without getting into too much detail about particular types of employees or particular locations or things like that, that would probably be okay. But there's a balancing act, and you just got to be mindful that all these comments that are submitted are potentially of public record. And if they're a public record, then FTC and everybody else can look at them and can glean whatever information they want from them and use them in other ways that may not be intended. So it's a balancing act.
Helpful. Next question I'm going to pose to the person here on my panel that I would go to if I wanted to get inside the mind of Lena Khan at the FTC. And so it's going to be Wendy. Is this initial draft sort of, you think something or attempt by the FTC to sort of put its marker out on the table and eventually is going to settle for something a little narrower? Or do you think there's a reasonable expectation from the agency that, this is one that the administration is going to fight for and they intend to sort of seek it full enforcement as it's proposed?
Yeah, if I were inside the mind of Lena Khan presumably believes wholeheartedly in the rule as proposed. She has been on kind of the emerging spectrum of antitrust reformers, shall we say, for quite some time. But I think the reality is that the rule will be something different than what is currently proposed, assuming there is a final rule. I do predict that there will be a final rule that is issued. Now, of course, as Michael talked about, there certainly are likely to be challenges to whatever proposed final rule is issued. But I think we'll see something different than we currently see now. That's the extent of my predictions. However, I will say that notably the FTC's proposed rule does ask for comments on alternatives, right? And I think we've touched on this. So they put these questions out there and propose potential alternatives. Not that they're actually proposing those as alternative rules, but they are putting this in the minds of the public that they are thinking about other types of non-compete rules that might be something less than a categorical ban nationwide. And so they're thinking about, whether it applies to certain classes of or types of workers, for example, applies to workers below a certain compensation threshold or workers who are classified as non-exempt. and maybe there's a rebuttable presumption of unlawfulness for other workers. Maybe there's some combination there of those two. But it is encouraging, by putting these alternatives out there, it is encouraging folks to comment on this if you have strong feelings about it. So we would encourage people that if you do have comments about the alternatives and or the current rule, certainly I would encourage you to submit comments, and Michael can certainly help you with those if you have questions about the comment process and drafting a comment that might be balanced in a way that won't put a target on your back.
Next question is for Scott. Scott, as management side labored employees, this is making our clients a little bit nervous about, even if this rule doesn't go into effect in the way that it's drafted, it's signaling sort of a little bit of a change in the wind of sort of the way that these agreements might be used. Do I need to be concerned about sort of agreements that I have with existing employees that prohibit them from competing against my business while they're employed, or using my information, or soliciting my clients? Is there a risk that this could impact those kind of agreements?
Yeah, so the one little bit of good news in this is I think that the rule is pretty clear, again, as it's drafted right now, and I wouldn't necessarily expect this part of it to change, but that this rule applies only to contract terms that would affect an employee after the conclusion of their employment. And if you go into the commentary on the rule, the FTC does come out and say this is not intended to cover contractual terms or policies or otherwise that prevent an employee from competing against you or from entering into some sort of arrangement that would pose a conflict of interest while they are employed by the company. So that is clear that the definition of non-compete applies only to these post-employment restrictions. Now, it gets a little bit confusing because the FTC then, when they talk about the de facto non-competes, I think we talked about, one of the examples that they call out is these agreements that say if you leave the company within a certain period of time, you're required to pay us back for training costs or pay us some sort of penalty or something like that, which that is the type of restriction that does apply when someone is employed. So those two concepts aren't necessarily reconciled perfectly in the FTC's commentary. I think that what the FTC, if I'm trying to read between the lines here, I think what the FTC is saying is that if you want to, for example, enter into a fixed term contract, and if the employee wants to get out, then they're required to pay a certain amount that would equal the damages for that breach. And, we can try and kind of estimate that. If it's reasonably related to the damage that the employer might incur, that kind of contract might hold up. But if you're going to impose this huge penalty on an employee that has no reasonable relation to how you are actually damaged as a business, as a way to sort of discourage someone from leaving you, that would fall within the definition of a non-compete. I don't know that makes a lot of sense logically that they're trying to stake out that position, but I think that's what they're trying to say with those. But for these, for the type of things where you say you can't go moonlight for our competitor at night when you're working for us in the daytime, those types of restrictions are still okay under the FTC rule.
As we get close to wrapping up here, I have one more for Chris that a concept that has come up is, there still are some acceptable restrictive covenants. You kind of gave a laundry list of the different families of those at the beginning. Can you give some examples about what we might feel like are permissible employee non-solicitation or not customer non-solicitation covenants that would likely fall outside the scope of these kind of these rules?
Yeah, you bet. Let me actually start with one that I think is the most enforceable and one that I think a lot of employers are going to be most concerned about, and that's confidentiality. And confidentiality provisions, confidentiality agreements, invention assignment agreements, those sorts of things, those are all backed by trade secret law, and I don't think that this rule, proposed or final, will have any impact upon employers. Still are allowed to tell employees, you can't take our confidential information, our trade secrets, and use it against us for a competing company later on. Somewhere in between is going to be non-solicitation covenants. A non-solicitation of customers oftentimes is viewed as a non-compete. And I think that we talked earlier about the de facto rule. If the non-solicitation of customers is so broad, or if the industry is a monopsony or a monopoly, it may well be the non-solicitation of customers is too broad. But the rule seems to indicate, at least the language or the supplemental materials that came with the rule seem to suggest that the FTC is actually okay with non-solicitation of customers as long as they're reasonable in scope and duration and the like. And then finally, non-solicitation of employees. I don't think this rule is going to have very much impact at all on that. There's a lot of case law that talks about how those are not restraints of trade. So if you say to a customer, or excuse me, if you say to your employee, if you leave, you can't then go recruit all the people that you used to work with, basically an anti-poaching agreement, that's not actually a restraint of trade, generally speaking. And so those probably are not going to be impacted by the rule. So if I was to rank it, confidentiality still enforceable, non-solicitation of employees most likely enforceable, non-solicitation of customers arguably still enforceable, non-competes prohibited according to this proposed rule.
Before I turn it over to Michael and Wendy for a final question about sort of enforcement, I thought, that point that Chris just made, Scott, why don't you share with the group, for those of us who practice in Wisconsin, sort of the unique quirk that our courts have sort of applied to that employee non-solicitation provision, sort of surprising restriction. Yeah.
I was just cringing a little bit on Chris because I do think we are the one exception to that rule about employee non-solicits, which we do have a case that came down a few years ago, which actually came out and said employee non-solicits are restraints of trade that need to be evaluated in the same way as non-competes and non-solicits. So we are
okay. Well, for the rest of you,
we are a little unique in that regard. So, but for the rest of you, you can continue. I think. I'm not aware of any other state that treats it that way, but we do have sort of a unique law here on that particular thing. So
this is a good example of sort of, Chris talked at the top about how this is sort of, state by state assessment. This is why, this is one of the things that keeps us working as employment lawyers, because there are so many quirks here. Okay, so final question. Yeah, go ahead.
I just want to jump in here and enter the fray of the non-solicitation discussion. Just a quick word of caution. DOJ has been prosecuting naked non-solicitation agreements, so non-solicitation agreements that have no kind of business purpose or justification other than to agree not to hire each other's employees. So those are under antitrust law, a per se legal antitrust offense, and DOJ has been at the forefront of bringing prosecutions relating to non-solicitation, naked non-solicitation agreements.
That's a great point. Yeah, that's a great point, Wendy. The non-solicitation covenants I was trying to describe would be tied to who the employee actually was soliciting while working for you. So if you have an employee who's soliciting Ford and then tries to go over to another company, it could be restrictive with respect to Ford, but it wouldn't necessarily be restrictive with respect to GM, or at least enforceable.
Great. So in a minute or two, Michael and Wendy, can you give us sort of just a sense about if in the nightmare scenario that this rule is actually implemented in a form similar to what it is right now, who has the standing to bring a claim? How is it enforced?
Well, go ahead, Wendy.
I'll jump in here really quickly and just say that the FTC believes it has the authority under Section 5 to open an investigation and to issue a complaint in situations where it thinks that Section 5 has been violated. So with respect to the 3 enforcement actions we saw brought the day before, the FTC clearly thinks it has the enforcement authority to, bring actions against companies who have issued or entered into these unlawful non-competes. So I'll turn it over to Michael to close this out with some additional thoughts on that piece.
Yeah, so the important point of all this is federal rulemaking. So theoretically, it would be what's called federal preemption. And depending on the scope of the rule may occupy all the state or displace all state law on non-competes. Or if the rule is more rifle shot and tailored, it may not. But in its current form, it's very possible that it could have a very wide preemptive effect, which would then, as Wendy noted, probably force all enforcement through the FTC, because there is no private cause of action for individuals to enforce the federal statute or the federal regulations at this time. So that adds another interesting wrinkle. And again, just being the admin guy here in DC, I don't think the FTC has the staff and the heft to be able to handle a flood of enforcement actions on something like this in the short term without significantly staffing up.
So maybe that's our nugget of good news to end our panel on. The FTC couldn't even enforce it if they tried, at least as it's structured right now. Scott, why don't you close us out here and talk a little bit about what we are thinking we can share with clients as sort of next steps as they think about this rule.
Yeah. So I think taking the questions in the chat as any guidance in all of us, we could probably sit here for another couple hours and just answer questions and ponder what this rule could mean. So please feel free to reach out to any of us, to any of our Husch, Blackwell, antitrust, labor and employment attorneys. We love to talk about this kind of stuff, and we're happy to help. In addition, we have some bonus content. Chris had mentioned in his last question that probably the most effective way for employers going forward, whether or not this rule goes into effect, is to protect their confidential information and trade secrets. And so in an effort with our intellectual property team, our trade secret team is going to be developing a trade secret improvement program to help certain companies shore up their trade secret protection and put themselves in a better situation, whether or not this rule does eventually go into effect. So for those of you who are on this webinar right now, we are offering a complimentary 1-hour trade secret strategy brainstorming session to the first 10 companies that sign up. So more on that will come in the follow-up email. For those of you, look out for those emails. And if you're interested in joining up for a complimentary 1-hour trade secret session, go ahead and do that. Those guys have some really great ideas about how to protect your trade secrets. And then whether or not this rule goes into effect, you'll be in a much better position to protect themselves going forward. As a reminder, I will just do some cleanup. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing, and a link to the Trade Secret Improvement Program information and survey. Remember, be one of those first 10 to sign up. And be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. Thanks, everyone, so much for submitting questions before and during the presentation. This was great. We're happy to answer more questions, but this concludes our webinar for today. So thanks, everybody.